next case is First Federal, Save the Loan versus Smith. Each party will have 15 minutes for the argument. Council, how long would you like to reserve for rebuttal?
5 minutes, please, Your Honor.
Thank you. I will be keeping track of time up here for each of you, so if you get down to a minute left, I'll let you know that at that time you're down to about a minute left. So you can sum up at that point. The arguments are being recorded, so when you come up, please introduce yourself. Please stay behind the podium because it's visually recording you, not just audibly recording you. Please speak loud enough so we can hear you and the system can pick you up. I don't think it applies in this case. If you had a victim or minor or child to refer to, please do that by initials. I don't think we have that issue here for federal. Having said that, we have read your brief and are ready to proceed whenever you are.
Good afternoon, Your Honor. Lane McKenzie here for the appellants, Jennifer Smith, or now known as Jennifer Hoops, and Andrew Hoops. Good afternoon. The Hoops today have assigned 2 assignments of error, but for the purposes of this oral argument, we truly only have 1 argument at law today. So I don't anticipate that my remarks will take the full 10 minutes, and I'll try and keep this brief for the benefit of all parties involved. Here, the Hoops challenged the trial court's jurisdiction when it entered the judgment entry of February 28, 2024, confirming the sale of their home while their appeal of the trial court's denial for their motion for relief was still pending. The Ohio Supreme Court has held consistently that once an appeal is perfected, that the trial court is divested of jurisdiction over matters that are inconsistent with the reviewing court's jurisdiction to reverse, modify, or affirm the judgment. This comes from the Electronic Classroom of Tomorrow, the Cuyahoga County Court of Common Pleas, 2011 Supreme Court case. This, in effect, means that the trial court does not have jurisdiction to take any action with respect to those claims that could be affected while the appeal is pending. Now, it is true that the Ohio Supreme Court has separately held that the mere filing of a notice of appeal from the order does not divest the court of jurisdiction to enforce an interlocutory or final order pending appeal unless the parties granted a stay of execution of the judgment. However, the premise that a stay is necessary to divest the trial court of jurisdiction has consistently only been applied to final orders or final judgments. It does not change the law divesting the trial court of jurisdiction when it would be inconsistent with the appeals court's ability to determine the appeal. Again, this comes from the Electronic Classroom case.
Counsel, can you explain,
Sure.
This is just a procedural nightmare as far as I'm concerned, but can you explain why the appeal that the original appeal would be inconsistent with the further ruling of the court?
Yes, so our perspective, the reason the original appeal was filed is we believe that there was case law out there that indicated that subsequent events after the entry of the consent judgment rendered it inequitable. However, and so for that reason, once we filed our motion to vacate the order of foreclosure, and that was denied, we then appealed that based on that case law. And then the critical operative part of that is that this court then issued a subsequent order in that appeal questioning whether the underlying foreclosure order was a final appealable order. I believe partially at least on the basis that it was not sure if that order resolved the claims of all parties to the actions, including I believe some lien creditors.
So what our court was saying is it looks like there might be some parties that their rights haven't been adjudicated yet.
Correct.
So it wasn't like, oh, a foreclosure is not a final appealable order, per se.
Yes, I believe it was just that specific the underlying entry that the foreclosure order was based upon was not final appealable, even though I believe there was language attached to it from the trial court that indicated that the trial court believed it was. I know this court then subsequently questioned that, and then during this court's consideration of that, that's when the trial court entered the confirmation, which is what we contend was the improper action at the time while this court was still determining whether the appeal was in fact a final appealable order. And then I'll go on to explain a little bit why, even if this court did determine that it wasn't final appealable, that the case law indicates that doesn't necessarily change the outcome of the analysis. So As I said, the Ohio Supreme Court has separately held that the mere filing of a notice of appeal from the order doesn't divest the court of jurisdiction to enforce an interlocutory or final order unless there's a stay of execution granted. However, that premise is necessarily only applied to final orders under Ohio case law. It does not change the law divesting the trial court of the ability to determine the appeal when it's considering the appeal's finality and appealability. In the current case, as we just discussed, on January 19th, 2024, this court issued an order to the Hoop's prior appeal of the trial court's denial of their motion for relief from judgment. That was the appellate case number 24CA012097. And that order stated in relevant part that the court questions whether the underlying foreclosure order was a final order. Therefore, the Hoop's appeal of the trial court's denial of their motion for relief was still pending, and this court was still considering if the underlying judgment was appealable when the trial court entered its confirmation entry. As such, under the electronic classroom and the precedent set by the Ohio Supreme Court, the trial court lacked authority and jurisdiction to take an action such as confirmation, which was inconsistent with this court's jurisdiction to consider, reverse, modify, or affirm the underlying judgment. Case law has made it furthermore clear that this divestment of jurisdiction is effective regardless of whether the court ultimately takes up the case. The Supreme Court in electronic classroom further held that even though the appeals court in that case eventually determined the decision was not an appealable order, the trial court was still divested of jurisdiction until the appeals court made that determination.
What does it matter, or does it matter? What's the implication, I guess, or the effect of your client dismissing that appeal?
We believe that, we dismissed the appeal because at that time we believed that the confirmation extinguished our ability to appeal the underlying foreclosure order. Typically, and I believe we touched on this in some of our briefs back and forth regarding the motion to dismiss the appeal, is that confirmation is a separate procedure from the actual foreclosure process. And once confirmation is entered, it effectively wipes out any ability to challenge the underlying foreclosure order unless that confirmation has been reversed or set aside. So that was the rationale for dismissing the appeal. Is we didn't believe it. We believe that under the law we didn't have the ability to maintain it.
So, I guess my point is, did that turn into then no harm, no foul? In other words, because then the court went off the confirmation, you were in the interim contesting it, but then you withdrew basically contesting it.
I wouldn't characterize our dismissal of the appeal as a withdrawal of contesting it. From our perspective, we would, if we were able to reverse the confirmation, that would open up the door to refiling the appeal and contesting again. We just felt procedurally that the appropriate action at the time was to dismiss so that we could file the current appeal of the confirmation rather than having two concurrent appeals ongoing at the same time. If the confirmation is reversed, that would open up several new avenues for the Hoops should they choose to pursue them, including the right of redemption would be reopened, the possibility of, as I mentioned previously, refiling their appeal as they had the first time. I'm not saying that either of those would be the action they would take in this instance, but that it would provide options to them should they so choose to pursue them. Moving on to the Supreme Court's decision in the electronic classroom case, the court held that the determination of an appropriateness of an appeal lies solely with the appellate court, and a trial court has no jurisdiction to continue with any issue inconsistent with that decision on appeal, regardless of the trial court's opinion on the appealability of the order. This appellate court has the authority to review an order that is labeled as final and appealable by the trial court to determine whether it truly meets the criteria for finality under Ohio law, and a trial court's indication that an order is final and appealable does not necessarily automatically make it so, and it's the appellate court which has to make that determination once an appeal has been filed. The judgment entry of February 28, 2024, confirming the sale was issued during the pendency of the Hoops' prior appeal, and therefore necessarily must be void, as it contravened this appellate court's exclusive domain to determine the appropriateness of the appeal and the validity of the decisions being appealed. The Hoops now receive reversal of the trial court's confirmation due to this lack of jurisdiction, And necessarily for the same reasons that I've discussed here today, we contend that there was also, if in the alternative, an abuse of the trial court's discretion that warrants reversal. Thank you.
Thank you. You'll have your full 5 minutes for it all.
Thank you.
Good morning, yes, still morning. Good morning, Your Honors. Chris Parker here for First Federal Savings and Loan Association of Lorain. May it please the court, Mr. McKenzie. The procedural quagmire is certainly accurate in this situation, and I think in order for the court to fully appreciate the issues that are presented, you have to look beyond just the confirmation order. You have to look at, and frankly, I think that the question Justice Carr, or Judge Carr, that you asked about whether or not it was a no harm, no foul on the dismissal of the 60B appeal is accurate. We believe that that is essentially a waiver of any issues to the extent that there were any viable issues associated with that appeal. Why do I say viable issues?
Except you can't waive jurisdiction, can you?
Well, arguably speaking, no, you cannot waive, you can waive jurisdiction over the first, and you can't waive subject matter
You can't give
jurisdiction.
the court jurisdiction if the
You
court
can't waive
doesn't have
subject matter jurisdiction. And in this situation, you look at the 60B appeal and you're appealing from a consent judgment. You're appealing from a judgment that didn't reserve the right to appeal. Like your argument you just heard with that sentencing, where there were certain things that should have, that were waived knowingly and voluntarily. Here, there was a knowing and voluntarily waiver of their rights under that consent judgment. They had the advice of counsel. They signed that consent judgment. So trying to set aside because they have new lawyers with new theories didn't save the day. The ECOT decision, which Mr. McKenzie wants to talk about, and I understand why. If I were in his shoes, I'd be arguing ECOT too. But ECOT is certainly not applicable here. ECOT involved an interlocutory appeal. This is a final appealable order. There's no question that the matters that were before the court were final and appealable. The motion for relief, there was also a motion asking for stay. The stay, the court issued an order requiring a bond. The bond wasn't posted. There was no stay. If ECOT is going to be applied across the board to both interlocutory and final appealable orders, then I guess we got to get rid of Civil Rule 62, because there's no such thing as a stay of execution. If you cannot appeal, if you are not permitted to proceed because there is a pending appeal of no matter what consequence, then there's no reason to stay execution or seek a stay of execution. There's no reason to require the posting of a bond.
But that all is presuming it's a final appeal.
And the confirmation, the foreclosure order was final and appealable.
Except that our court said, we're not sure.
Your court asked for discussion, which was briefed by the appellee. We submitted a brief, and the foreclosure order does what virtually every foreclosure order around the state of Ohio does. It marshaled the liens, and it said that the liens of the junior lien holders attached to the proceeds of sale to the extent that there were any proceeds of sale. And those junior lien holders, as with every other foreclosure in all 88 counties in Ohio, then come forward, if there are excess proceeds, to say there are excess proceeds, we believe we have the right to those excess proceeds because of our position. So the foreclosure order did exactly what it is supposed to do. It granted judgment in favor of the bank. It identified that the treasurer had the first and best lien. It identified the costs that were due. It marshaled all of the claims that were presented, and it said for those remaining junior lien holders, you have the right to pursue excess proceeds to the extent that there are any. So that was a final appealable order. There's no question about that. Again, this is an abuse of discretion. I understand why he's talking about jurisdiction, but the jurisdiction argument is a red herring. There was clearly jurisdiction for the trial court to continue to proceed. The safeguards that the hoops could have exercised were simply not exercised. They were given the ability to post a bond. If they didn't like the bond, 62 tells them to come here and argue about the bond not being effective or being too high or conditions inappropriate. That wasn't done. So there are a series of steps that they could have exercised that they didn't. And as a consequence, there was no question that the trial court had the ability. The confirmation order did exactly what it is supposed to do. It talked about confirming the sale. It talked about the computation of the final amount. It assessed the interest. It did all of the marshaling that was also in the foreclosure order. So there was nothing inappropriate with the confirmation order. And again, we get back to the original consent order that waived all defenses. Can you waive jurisdiction? Judge Carter, maybe not. But if that's the case, then you would argue whether or not there was even jurisdiction to enter the consent order. And to me, that is reaching a point that makes no sense. They've waived all of those rights, and there was clearly jurisdiction in the trial court to enter the confirmation order. ECOT, because it was not an interlocutory order, it was a final appealable order, and as a consequence, the decision that we referenced in Curl is the appropriate statement of the law on these issues. It does not divest the trial court to enforce unless a stay of execution is granted. That was never issued, and as a consequence, because it's a final appealable order, the trial court had the authority to enter the confirmation. It's been briefed in this appeal, the motion practice leading to this appeal, briefed in the prior appeal, the motion practice to the prior appeal that was dismissed. I feel like I'm telling you stuff that you've already read a lot of different times. So if there are questions, I'm happy to answer. If there aren't, I thank you for your attention, and I will sit down.
Seeing now, thank you.
To the extent that Mr. Parker wants to discuss the underlying consent judgment, I would respectfully submit that that's simply a separate issue and not relevant to the procedural process, to the procedural questions that we have in front of us. In the cases that he has cited, as well as we have cited too in our briefs, including the City Mortgage Inc. v. Rusnowski, it's been clear under Ohio law that confirmation of a foreclosure order is a completely separate matter from the foreclosure itself. Therefore, I would say that any waiver of the ability to appeal or challenge defenses in this case does not apply to subsequent proceedings pursuant to that order. The appellees in this case retain the right to question the procedural validity of the confirmation of the sale process, regardless of what rights were or weren't waived under the underlying consent judgment. Also, to the extent that the council brought up the fact that the appellees or the appellants could have sought relief from this court, the practical reality of this case was that we simply weren't afforded that opportunity. On January 30th, 2024, it was the trial court entered an order that ostensibly granted the appellee's motion for stay. However, it was contingent on them posting the full judgment amount in excess of $600,000 as a supersedious bond. And furthermore, the trial court only granted the appellees or the appellants until February 5th to post that full amount, which was just a mere 6 days from when the trial court entered that ruling on its motion to stay. And also, just simply as a practical matter, our office did not receive any notification from the clerk of courts of Lorain that there had been an order entered on that motion for stay. So even if we had been able to, within that time frame, attempt to apply for relief from this court for that stay, the time frame which the trial court provided for that to be done would not, regardless either way in practice, would not have afforded the appellants any relief in this case.
Order in Lorain County sent by mail to parties. If not sent electronically, they mail a copy of the order to you when you talk about notice of their decisions. How would you get that, a mail decision, copy of the decision?
Typically, it would either be a mail copy of the decision or to be quite frank with you, we have had issues prior with getting proper notice from the court in that case. I don't mean to point fingers and say it was the fault of any party, but there had been a prior order in that case that had also come in that we weren't aware of until we had taken the initiative ourselves to actively begin trolling the docket and seeing what had been entered in online. So there was certainly a lag there as well. But typically, yes, I believe the method that we were expecting was through mail, and that we simply never got that. Finally, to the extent that council talks about Rule 62A simply being nullified, I suppose, under this standard, this is only implicated in the instances where the appeals court appropriately or inappropriately, it's not my prerogative to question this court's judgment on which orders are final, appealable or not. It's only implicated in those instances where the appeals court thinks there's an issue as to the finality and appealability of the order. So I don't believe there's any merits to the idea that this somehow abrogates Civil Rule 62. This is simply filling a narrow gap in between the finality and appealability of interlocutory and final orders. Thank you.
Thank you. And I know that you folks have been working with our mediation department, not getting the results of that. Even though we denied the motion continue today, certainly continue on that process. If there's progress made, keep in touch with the mediator, let the mediator know that. If there are things I'm sure that you feel the mediator can help you with further meetings, I'm sure he'd be happy to do that as well going forward.
To the extent that, just because the court required, Lane and I continue to talk, and as recently as this morning, before we both got in our cars to drive here, he provided me with an update on where proceedings are. Yesterday, we were talking as well, I provided him an update on where we are. We're still working those lines, but
If you have some resolution that a order from this court or decision of this court would create problems, let the mediator know that, and perhaps he can advise some filing so that we could go from there. But if it gets to that point, but having said that, otherwise the court will take the matter under advisement and issue a decision in due course. When that decision is reached, the clerk will mail a copy of that decision to you, and also be available on the High Supreme Court website. Having said that, I think both of you please agree to take this.
thank you, judges.
Thank you.